Respected ma'am and dear participants, a very good evening to all of you. I, Raj, member of Legal Vidya, welcome you all to this workshop on Rera. So, without any further ado, let's begin this session. This marks your third session of this workshop. Over to you, ma'am.
Good evening, everyone. Today is our third session, which is a conclusive session of this 3-day workshop. Without wasting any time, let's start with the session. Give me a moment, I shall present the screen to you. In our last session, we had understood what all an application in Rera would entail. We can go through a quick recap so that we can continue this session. We had learned in section 3 that why Rera application is important, because no promoter can sell or advertise or market any property in a real estate project without first registering it under Rera. The only time you won't have to register the project under Rera would be, for example, if a builder is constructing a small residential building only with, say, 6 apartments on a 400 square meter plot. Since the plot is below 500 square meter and below 8 apartment threshold, he or she need not require to go to Rera for a registration. So that's what we learned in section 3. And section 4, we had learned what all documents are required for a promoter to get himself registered with Rera. Let's recap that. First, what a promoter needs to register with the Rera would be the application fees. Every promoter must apply for project registration with the authority in the form and must pay the liable fee. And there are certain mandatory documents that we had read under this section, which included enterprises detail of the builder, which would include the name of the builder, type of the construction that he's going to take, whether it's residential, commercial, the registration of the promoter, his company, and names and photos. He will also have to upload past 5 years project details, which would also include status of each of such project, if there are any ongoing delays in such project, if there are pending legal cases on those projects, the type of land, and also pending payments on those projects of 5 years. You will also need to have authenticated approvals and commencement certificate, as we had discussed. For phase-wise projects, he will need approval for each of such phase and sanctioned planned layouts, specification of certain project, development plan and sanction plan. The difference is a development plan include facilities like fire safety, water supply, evacuation, renewable energy source, what he's going to use for that particular project. Also, project location, he will have to mention in the plan with clear demarcation and boundaries. The latitude and the longitude of the project needs to be intact. He will also have to fill in a pro forma of and an allotment letter, the agreement for sale of each allottees, and the conveyance deed that the builder obtains for further construction of the real estate project. The details of apartment will also be a part of the application process. Basically, how many apartments are there in that project, type, basically say Lower area is commercial, upper area is residential premises, the carpet area basically जो भी चार दीवारी के अंदर होता है वो carpet area है. So the carpet area, balconies, open terraces, all of those information needs to be a part of the development plan and sanction layout. The number of area also includes the garages for sale. And he will also have to put in the real estate agent's details. Also the details of the contractors, architects and engineers. The most important thing that he would be also filing would be his declaration in a form of an affidavit and the legal title to the land. Basically, to avail that land, what are the valid documents that he has to prove his ownership over that land? If the land is free from encumbrances, then the details of such land also he will have to attach in the project details, which will be then checked by the RERA authority. He will also have to give the completion timeline of project phase wise if there are multiple phases. And we also learned that 70% of the funds collected from the allottees will be deposited in a scheduled bank account and will be only used for land and construction costs. And if he decides to make withdrawals after completing those 30% operational costs, then he must have a certified letter from an engineer, architect, and a CA, ensuring that the proportional use per project is completed. Also, there is an audit requirement. Promoter must get his accounts audited annually within 6 months period to ensure compliance with all the funds that he has utilized. This was a quick recap for the documents that the promoter has to upload. The continuation of the same would be grant of registration. Once a promoter has already applied, once a promoter has already filed for registration, just a second. Yes, on receipt of application under subsection 1 of section 4, the authority shall within a period of 30 days grant a registration subject to promotions of, sorry, just give me a second. I'm a bit distracted. Give me a minute, guys. Okay. Once the promoter applies for registration, RERA authorities must decide within 30 days whether to approve or reject the application. Okay, so that's what's mentioned here. Grant registration subject to provisions of this act and rules and regulations made thereunder, and provide a registration number to the promoter, which would also include a login ID and password, which only the promoter shall have access to. And he will also get access to the website and furnish all the details which is approved by RERA, and all the 6 months updates he will have to put on the same website, for which he must have created the web page. Second part is rejecting the application. If the application, for reasons to be recorded in writing, if such application does not conform to the provisions of this act or rules or regulations made hereunder, provided that no application shall be rejected unless the applicant has been given an opportunity of being heard in the matter. So if they want to reject a certain application, they will have to give it in writing on what grounds the application is being rejected. And if the authority fails to give reasons as to which they are rejecting, or they've not given a yes to the project, then automatically in 30-day time period, the project is deemed to have been approved. That's what we'll learn here ahead. If the authority fails to grant the registration or reject the application, as the case may be, the project shall be deemed to have been registered, and the authority shall, within a period of 7 days of the expiry of the said 30 days specified under subsection 1, provide a registration number and login ID and password to the promoter for accessing the website of the authority to create his web page and to fill therein the details of his proposed project. The registration granted under this section shall be valid for a period declared by the promoter. Basically, he will have to mention the details. He must have committed the time for phase 1, phase 2, whatever time he's committed, he has to complete the project in that time frame. So he will have to also fill in that information. For example, if a certain developer gives Rera registration and the authority does not respond in 30 days, the project is registered automatically. Now, how can a project get registered, or how can a project get electricity and water without an OC? In some cases, builders manage to provide electricity and water supply even if the project doesn't have OC, and this happens only via temporary connections. The builders obtain temporary water and electricity connections, and during such construction, some illegal activities, if the BMC is aware of those illegal activities, then they would have to put a stay order on those projects. Now the next part is extension of registration. If the registration granted under section 5 may be extended by the authority on an application made by the promoter due to force majeure, basically earthquakes, famine, COVID, basically situations which are not man-made but are force of nature. In such form, if such payment or such fees due to such force in such form and on such payment of fees as may be prescribed, provided that the authority may, in reasonable circumstances, without default on the part of the promoter, based on the facts each such case and for reasons to be recorded in writing, extend the registration granted to a project for such time as it considers necessary, which shall in aggregate not exceed a period of 1 year. Even if they are getting extension for filing Rera project, despite force majeure, it won't exceed a period of 1 year. They will have to comply with all the requirements necessary within a period of 1 year. Provided that no further application for extension of registration shall be rejected unless the applicant has been given an opportunity of being heard in the matter. If they are rejecting the application, then the Rera authority will have to give an opportunity to the promoter as to what are his excuses. Now that we've learned about how to file for Rera application, how the Rera application gets granted, and also the extension period. Also, a Rera registration can get revoked by the Rera authority. Basically, if a promoter violates a law, regulation, or indulges in unfair or fraudulent practices, then on certain grounds the license can also be revoked, which would usually be non-compliance if the promoter fails to follow the rules and regulations, or approvals that he's received. If he violates them, then if the promoter does not adhere to the terms for the approval which was granted by Rera or by even the BMC or the competent authorities, then the license, the Rera application can be revoked. If the builder is indulging in unfair trade practices or misrepresentation or making false claims, and if Rera authority becomes aware about such claims, then in such adverse situation, the Rera authority will cancel the registration. We must have seen many times misleading promotions or fake affiliations, basically claiming that approvals the promoter doesn't have those approvals, but he claims that he's gotten approvals for these many amenities or this kind of a township, but in reality he doesn't get those approvals. And if he's fraudulently advertising himself and lying to the allottees, then he's cheating, and in such case the license can be revoked. But even for that, the RERA will have to give a 30-day notice period in writing, and will also have to state the reasons for the revocation of license. The promoter will present reasons why the registration should not be revoked, but if he fails to explain the reasons fairly, then the license is revoked. And sometimes, instead of revoking a license, instead of canceling, a lot of times authority may allow certain projects to continue, but they will give us strict guidelines or strict conditions for the benefits of the buyers, because there are consequences of revocation, right? RERA doesn't directly revoke a license, because it leads to the promoter being blacklisted. Their name is published as a defaulter, and a photo is displayed on a RERA's website. And other state RERA authorities are also subsequently informed if the license is revoked. And there are certain project completion measures that the RERA authority will have to take. The authority will have to take steps to ensure that the work is completed, the development work. It will be subsequently given to another promoter, and the funds from the promoter's project bank account, they will be frozen and later used for completion and will be given to another promoter. So hence it in turn also protects the home buyers and public interest. I hope this was clear. I will just check. Is it clear? Please write yes in the chat box if it is clear. Am I going too fast, or is it okay, the speed?
Also, you can turn on your microphone as the permission has been granted to all of
My
you.
microphone is not on.
No, ma'am, I am asking the participants if all are clear to them.
Okay. Sure.
Yes, ma'am.
Now let's understand, if a builder is not registering himself under RERA, then what does it entail in terms of punishment? Section 59 describes the punishment for non-registration under Section 3, which is registration of RERA project. If any promoter contravenes the provisions of Section 3, he shall be liable to a penalty which may extend up to 10%, meaning they have capped it, of the estimated cost of the real estate project as determined by the authority. Now this 10% goes in crores, students, because it's the entire project's estimated cost, not even phase wise. So if a promoter is not getting himself registered, he will be facing huge penalties. And if any promoter does not comply with the orders, decisions, or directions issued under subsection 1 or continues to violate the provisions of section 3, he shall be punishable with imprisonment for a term which may be extended to 3 years, or with fine which may extend up to a further 10%. Basically, if still the promoter is not following the guidelines, 10% penalty has been levied. If he's still defaulting on getting himself registered, a further 10% on the same project shall be levied on him as in terms of penalty, and he can also face prison for up to 3 years, or it could be both. A quick recap: if a promoter fails to register a real estate project as required under section 3, they may be fined up to 10% of project's estimated cost. And if they still ignore, they continue the violation, the promoter ignores the penalty order, or continues to operate without a registration, the promoter may face imprisonment for up to 3 years and an additional fine up to 10% of the project's estimated cost. Even both imprisonment and fine is leviable. This section is important because all real estate projects are registered under Rera, and it will in turn also promote transparency and accountability. It will protect the interest of home buyers from unregulated and potentially fraudulent developers. Initially, authority will impose a monetary pressure for non-registration, but if the promoter still doesn't understand by that monetary pressure, if he still doesn't comply, then we do have provision for a strict legal action. It also includes jail time. Now let's understand how are consumers protected. Consumer complaint under Rera. This is the final topic in the 3-day lecture series. To understand how a consumer protected, in the first lecture we understood why Rera was introduced, because despite of Consumer Protection Act, despite of other laws, the builders were still evading the liability and were still fooling home buyers by one small loophole, which was by proving that a home buyer is not a consumer and hence cannot file case under Consumer Protection Act. And another loophole was, if you're not a home buyer, what if you're an investor? What if you're a commercial investor? Then those people were not covered under consumers definition as per Consumer Protection Act. Let's understand here what a consumer means. Consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised, or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for consideration paid or promised or partly paid or partly promised under any system of deferred payment. When such use is made with the approval of such person but does not include a person who obtains such goods for resale or for any commercial purpose. What it's here trying to say is, a consideration needs to be involved for a person to be a consumer, whether it is a partial payment or a full frontal payment. Important here is he should be a consumer and he should have paid to avail whether that product or whether a particular service. Yes, even services are included in under consumer protection. Here, the second part, hires or avails any service for a consideration which has been paid or partly promised under any system of deferred payment and includes any beneficiary of such service other than the person who hires or avails for the services for consideration paid or promised or partly paid and partly promised, or under any system of deferred payment when such services are availed of with the approval of first mentioned person but does not include a person who avails of such service for any commercial purpose. Okay, I'm sure this is confusing. What it's trying to say here is that the consumer is a person who is the end user and not a businessman. For example, if a tailoring machine is being bought by a tailor, write in the chat box, would the tailor be a consumer or not? Is the PPT not visible? Next section screen. Okay. A tailor would be considered a consumer here because he's not buying that tailoring machine with an intention to again sell it. He will use that to go ahead and do the business. So in this case, a tailor would be considered a consumer, but a person, a retailer, he won't be considered a consumer because he has an intention to do commerce. He has an intention to make profits by selling that product. But in this case, a tailor would be a consumer because he doesn't intend on selling the machine. He intends on selling the products that he will create via using that particular machine. That's what the second section of this section entails. Is this clear? Tailor has it for his personal use. Business use, Tailor has it for his business use, but the business is not selling the machine, but rather the products that he will be creating from that machine. Similarly, say a hardware or a software, these SAP, these CAs, and a lot of auditors and accountants use these softwares, right? They are consumers. They are not intending to sell that particular software, but they will get results in their business based on that software. So what builders used to do was they used to evade the liability by saying that this is not a home buyer. How is this a person, a consumer? And this person cannot file a case here because this person is not a consumer. He already has a home. He's an investor. So hence there was a very urgency for an act that covers home buyers, investors, basically allottees, promoters, agents, all of it. This is why Rera came into the picture. I hope this was clear who a consumer is. The key features of Rera we've understood: mandatory Rera registration for projects and builders. Builders must disclose project details. There are strict penalties for delays and fraud, and it needs to be consumer friendly dispute resolution. That's the key reason why Rera was introduced, so that home buyers are protected and the resolution is quicker. What are the common consumer issues in real estate? The problems faced by home buyers majorly include delays in possessions. A builder promises a certain timeline that I'll give you in 3 years or 4 years time period, the possession, but the builder ends up not delivering for years to come. This does happen. This scenario does happen. This is a very important problem that Rera is focusing on, because a lot of finances are involved of people. People are on rents, not being able to figure out how to pay rent because they have their premises under construction. Then project plan changes. Basically, initial promise was made that a project would be made with this kind of a layout. You will be getting balconies, you will be getting, each home buyer will be getting a personal parking space. Huge promises were made. But eventually, once they have allottees' interests and funds in their account, plan changes. This won't be a case because in Rera, the promoter will have to take permission from the allottees for certain project changes. Another problem was poor construction quality. Builders used to use very bad material for their buildings, which used to not even stay for 6 years, 7 years, huge cracks, the foundation is not good, and used to not even cover it. And many hidden costs and extra charges he would give. Like, for example, it is promised that you will get possession in this much time, and then by the time the allottee is taking the possession, the builder is like, you had this much area, but I have given you extra, so you will have to pay the gap. A person might not be interested in paying for that extra area because he did not agree to such change. So certain hidden costs were levied and false promises in advertisement. This still happens. We see that when a builder has made a banner, they show very lavish project, and then in turn it's not so minute changes are okay, but you can't make huge false promises in terms of advertisements with an intention to loot your allottees. What are the legal provisions for consumer protection? There are certain functions and duties a promoter has been entailed with in RERA. First one is register the real estate project with the RERA before advertising and selling, which will again, because you are registering, RERA will do its due diligence and safeguard home buyers' interest, provide comprehensive project details, including sanctioned plans, layout plans, and specifications approved by the competent authority. They also have made the information segue very transparent by creating a web page on the RERA website to display project information for public viewing, which the promoter will have to regularly update the project status, including the number and the types of unit booked. If he's making more sales, he will also have to update that within the time period of quarterly. We had learned, right? 3 months. Every 3 months, he will have to make those changes. And the approvals that he's obtaining, he will have to update it quarterly, and the pending payments, all the quarterly progress reports. So by this, RERA made the information very transparent for the consumers. You just need to go on the web page, check the project details, and you will get all the information that's necessary. Compliance and certificate. They did make registration compulsory. They did make information compulsory. They also focused a lot more on compliance and certification part. They have made it compulsory to obtain all the necessary completion and occupancy certificates from all the relevant authority, so that no governmental dues and charges related to the project are remaining unpaid. They have focused on allottee engagement. However, they focused on allottee engagement by providing allottees with essential project information at the time of booking and the timeline completion. And they also promote good projects. They facilitate the formation of an association or society of allottees as per the applicable bylaws. They have made the promoters financially very accountable. Just give me a second. Sorry, there was a little disturbance in the environment, so I had muted. I'm so sorry. Okay. RERA also made it a very strict financial accountability that the 70% amount that are realized from the allottees would be kept in a separate bank account. What are the obligations of promoters regarding advertisement? Section 12 explains that where any person makes an advance or a deposit on the basis of the information contained in the notice, advertisement, or prospectus, or on the basis of any model apartment, plot, or building, as the case may be, and sustains any loss or damage by reason of incorrect false statement included therein, he shall be compensated by the promoter in the manner as provided under this act. If a builder is using a certain pamphlet or a proposal, an official proposal that you get while you're buying a apartment or a unit in a particular project, if it does not meet the promises and the expectations in real, then you can file a complaint in Rera, and the builder will be liable to compensate to you accordingly, whether it is financially or by making changes in what he had promised to you. Provided that if the person affected by such incorrect, false statement contained in the notice, advertisement, or prospectus, or the model apartment, plot, or building, as the case may be, intends to withdraw from the proposed projects, he shall be returned his entire investment along with interest at such rate as may be prescribed, and the compensation in the manner provided under this act. If a person does not want compensation and is just requesting that, please, I just want my consideration back, then the interest which is agreed in the agreement, along with that interest, the builder will have to refund because he has fraudulently made false advertisement and claims. Section 31 deals with filing of complaints under Rera. In Section 31 of Rera, they've provided a mechanism for addressing all the grievances related to real estate transactions. It empowers individuals and associations to file complaints against promoters, allottees. It's not necessary that always promoters are defaulting. It could also be an allottee who is not making his dues clear, or maybe an allottee who's created third charge on the unit that he has, or he's resold the apartment that he's purchased from the builder, hence creating litigation. Many such allottee related problems also do exist. Or real estate agent for the violations of the act. Even real estate agents, if they end up selling the apartment by making false promises, even they are covered in the complaints that you can file. The eligibility to file a complaint would be any aggrieved person has the right to complain. Aggrieved here meaning, when would you be aggrieved? When there is an interest in a certain property or a transaction. The term person includes individual allottees, basically home buyers, association of allottees, home buyers associations, and voluntary consumer associations registered under existing laws. What are the grounds for complaint? The complaints can be lodged for any violation or contravention of any of the provisions that we've understood in this act. The rules and regulations formulated under Rera. If you see a violation, you can reach out to Rera website and file a complaint with the adjudicating Rera authority. Who could be the respondents in the complaint? The complaints can be directed against all three parties: promoters, allottees, and real estate agents. The filing procedure is complaints. You have to go on the web page of the Rera, and the adjudicating officer is thereafter designated. What is the filing procedure? First, you have to visit. Every state has an official Rera website. Maharashtra has also one. Similarly, Delhi will have one. Every state will have their own Rera website. You will have to go on that official state's website, Search for the complaint registration page of the site. Click on the page or click on the complaint registration, wherein you will be redirected to a Rera complaint form. And here you must fill in all the required details about your complaints. You have to note that you will have to furnish some personal information like name, address, contact numbers, etc., along with supporting documents to verify why your complaint is authentic. Once the form has been duly filled, you can file a complaint by paying rupees 1,000. A 1,000 rupees challan will be generated, which you will have to pay. If you complain to an adjudicating officer, you need to pay rupees 5,000. It's either or depending on what kind of complaint you're going to file. You can complete these transactions online, transaction of complaint online very efficiently. Now you've already complained in Rera authority and you did not get your redressal, or if you're not satisfied, within 60 days, Rera authority will take a decision. But if you're still not satisfied in that decision that the authority has taken, there is a redressal mechanism. You can appeal to the appellate tribunal of Rera. For here in Maharashtra, in Mumbai, Rera office is situated in Bandra. Similarly, state-wise appellate tribunals are there. You can register your complaint. If the parties to the complaints are not satisfied with Rera authority order, they can file appeal to the Rera appellate tribunal within 60 days of receiving the decision. And this decision will be taken as a decision of any civil court. It has that standing. Filing deadline. Appeals must be filed within 60 days of receiving the decision, and the tribunal may accept late appeals only if sufficient cause for such a delay is demonstrated to them. Tribunal's authority. Upon receiving an application, the tribunal can issue orders, including interim relief. Even if there's a suo motu case, if appellate tribunal thinks that the authorities below it doesn't have a fair order, then they can give interim relief also, and they can hear both the parties, take up a case on its own. Suo motu basically means on their own. Third thing that's really ensured here is timely resolution. The tribunal aims to resolve all the appeals within 60 days, and if it is unable to do so, which does happen, it must record the reasons for the delays and the powers that the tribunal can examine the legality and correctness of decisions made by the authority or the adjudicating officer, either on its own motion or upon request by the parties. What are the penalties for non-compliance by promoters? Section 63 deals with the penalty for failure to comply with the orders of the authority. If any promoter who fails to comply with or contravenes any of the orders or directions of the authority, he shall be liable to a penalty for every day during which such default continues, which may cumulatively extend up to 5% of the estimated cost of the real estate project as determined by the authority. And section 64 deals with if the promoter is not complying with the Rera authority's order, then in such a case, if any promoter who fails to comply or contravenes any orders or decisions of the appellate tribunal, he shall be punished with the imprisonment for a term which may extend up to 3 years, or with fine for every day during which such default continues, which can then extend to 10%. In Rera authority, here it is 5%, and if the complaint was filed in appellate tribunal and the promoter did not abide, then it is 10% of the project cost, or both. Section 67 deals with penalty for failure to comply with the orders of authority by the allottee. If any allottee who fails to comply or contravenes any of the orders, decisions, or directions of the authority, he shall be liable to a penalty for a period during which such default continues, which may cumulatively extend up to 5% of the plot. Basically, if he's invested in the plot, then the percentage would be calculated on that plot, apartment, or building cost, as the case may be. The penalty for failure to comply with the orders of appellate tribunal by allottee. If any allottee who fails to comply with or contravenes any of the orders or directions of appellate tribunal, as the case may be, he shall be punished with the imprisonment for a term which may extend up to 1 year, or with fine for every day during which such default continues, which may cumulatively extend up to 10% of the plot, apartment, building cost, as the case may be, or it could be both. Here we come to an end for the lecture series. If you all have doubts, please feel free to ask me.
Hello, Miss.
Yes.
If the promoter or the builder or the this builder or the promoter is taking up the project for the first time, so
Hmm.
how can he be showing the previous 5 years,
Hmm.
the projects, ongoing
He
projects or
won't be showing the 5 years project because he's first time a promoter. Then that will be his first project. It's not necessary that you need to upload 5 years of project. You could have 2 years detail, 3 years detail, whatever is available. His
okay.
company would be
And
registered, right? So they will cross check. Yes.
okay, and within how many, is there any limitation period for lodging a complaint against the builders or the allottees or the
60 days,
promoter?
as we learned, 60 days. And if you are exceeding that, then you can give your recorded reasons. If it's been couple of months also, then you can say that you were not aware in the first place that this is happening. So you can still make a fair case and lodge a complaint.
Thank you, thank you.
Welcome. Anyone else?
Hello,
Yes.
Disha ma'am. From KS Law College, SOLLB,
Okay.
and I had recently attended Rera training,
Mm-hmm.
and I am yet to give my exams for the
Mm-hmm.
agent
Mm-hmm.
certificate.
Mm-hmm.
Actually, the training was very good, but couple of questions ka answer I couldn't get over there because they are more into training and not into law. Okay, my question was related to law, more related to law.
Correct.
Yeah. So I wanted to ask that
Mm-hmm.
in some of the cases,
Mm-hmm.
the promoter gets penalized when we complain to Maharera.
Mm-hmm.
And there was, I think, jail term or something was mentioned over there.
Yes. 3 years.
Yeah, yeah. So I had asked in my training, but they were not from the law side, so they were not knowing it. Otherwise, training was very good. So my
Mm-hmm.
question was, the jail term, is it a bailable or non-bailable for the promoter?
Mm-hmm. Jail term bailable or non-bailable?
Yeah.
Just let me check this. Good question. I'll have to get back to you, but I think it is a
Okay.
bailable offense.
Okay. And if it is bailable, then I'm sure that it must be compoundable, right?
Yes.
Okay. And further,
Hmm.
supposing if it is non-bailable, okay,
Hmm. Hmm.
then can the I mean, I'm taking all the situation. Can the promoter take a anticipatory bail in that case?
So I think if the uh, offense is really severe, then it will be non-bailable, right? Because RERA has authority over even civil laws, correct? So
Mm-hmm.
it can be non-bailable also. But if
Mm-hmm.
there is a small violation if a builder has done, then
Mm-hmm.
they might grant a bail and he might be given. There are a lot of times because of money laundering or different cases, builders are in jail and they request bail and they say कि मैं जेल में हूँ तो उससे
Mm-hmm.
अच्छा मैं बाहर रह के प्रोजेक्ट कंप्लीट करके दे देता हूँ करेक्ट बिकॉज यू विल बी इन
Mm-hmm.
जेल you will just increase the process correct
Mm-hmm.
if there is a fair point then I have seen people getting bail the promoters getting bail but it
Mm-hmm.
depends on the RERA authority and the
Mm-hmm.
how severe is the complaint.
Yeah, ma'am, I
If
know,
he's
but
done major default, then of course they won't give bail.
yeah, ma'am. So I know that always depends on the situation, but
Right.
here it is only mentioned jail term, so we are not getting any answer from there.
Right, but then there are other laws that come into the picture, right?
Right?
Then it's
Yeah,
also
yeah, yeah.
that it's also up to discretion of the RERA authority, no?
Yeah, yeah.
So yes, so
Okay,
well.
okay. And ma'am, one more thing. Uh,
Mm-hmm.
when the allotee
Mm-hmm.
uh, signs an agreement of allotment, okay.
Mm-hmm.
So let's say a main promoter, okay.
Mm-hmm.
So or whoever has the land, he will only sign or his power of attorney can also be used. And if it's
The
he
power of
he's a
attorney can be used.
huh?
Power of attorney can be used because builders don't come to registration office. They send their power of attorney who has the powers to make signature. Whenever there's a
Okay.
project being registered, you will
Hmm.
see that in registrar's office, most
Hmm.
of the time the builder's power of attorney will come.
Hmm. Yeah, ma'am, very
So the
correct.
power of
So
attorney
when
has a right.
when an allotee goes to the for buying a new flat, okay.
Hmm. Hmm.
Of course, there would be so many person at the promoter's site, right?
Right. Right.
So, for example, I'm just giving you an example. I'm going to buy a flat in a Godrej. Okay.
Hmm. Hmm.
Now, Godrej being a very reputed, and so yeah, I'm not going on that. But if I'm going to any promoter or builder, okay,
Hmm. Hmm.
and I do not know because there would be so many person working over there. Okay.
Right.
So how do I know that he has a power of attorney and he is the right person when I'm going as a layman or just to buy a flat?
So see here, no, when you are going to buy a flat, you
Hmm.
will only it will only become a consent via signing a contract, right? If you end up paying a token amount or something, then you will
Hmm.
enter
Hmm.
a contract, correct?
Right.
Yes. So based on that contract, you will also have that copy, won't you?
Hmm.
That will be enough
Hmm.
proof for you to furnish in the RERA complaint.
No, ma'am. I'm not talking about any complaint. I'm saying when
You don't need to
both of
personally know a promoter. No, now Hiranandani and all of these people, they are huge promoters. You will never reach them out. They are not going to
no,
come.
ma'am. No, ma'am. I'm not talking about promoter. I'm saying when
Hmm.
a flat buyer goes for buying a flat. Okay.
Where will the flat buyer go to buy the flat?
Yeah, yeah, that's what I'm coming to. So
Hmm.
finally, the flat will get transferred on his or her name only when the registration and stamp duty is paid to the
Yes.
government,
Yes.
right?
Correct.
Huh. Huh.
Correct.
So that time, when the flat buyer goes, allotee goes, okay,
Hmm.
and whoever the power of attorney of Hiranandani or any group comes over there, okay, how the flat buyer would come to know that he is the right power of attorney person from
Power
this
of
promoter?
attorney is attached. It's annexed in the agreement. Right, whenever you'll see no power of attorney, also the registrar will check. No, he won't let another party stand in front. There will be two witnesses also there. His identification will also be checked there at the registrar's office.
Ma'am, you are very correct. But when I was doing a
See, if you
training, no,
have
that
a
time.
doubt, no, I'm trying to sort it out. But I would like others to also have question here, because see, this is not a doubt, right? This is you have to be aware, and the power of attorney is attached. So I'm not
Hello.
getting a good question there. So I hope I was
Bolo.
able to help you, Sohil. But
Yeah,
I think there are others also, maybe
yeah,
with genuine doubts. I would like to hear them out.
Hello.
Yes. Hello. Hi, Sachin.
Hello, ma'am. I just wanted to know how to do quarterly
You're
compliance
not audible.
or how to do quarterly compliance or which circular can make मतलब how वो कौन सा सर्कुलर है जिससे मैं जान सकता हूँ कि मैं क्वार्टरली कंप्लाइंस कर सकता हूँ.
So the quarterly compliance would be done by the builder and the CAs that they have. They have their login ID and password, and they have those compulsory details to fill in. A lot of times they do skip on it, and they end up filling details for 2 quarters at once.
कौन सा कंप्लाइंस करना चाहिए उसका गाइडलाइन कौन से सर्कुलर में है.
So when we were seeing, quarterly compliance basically depends phase wise and project wise, right? So Rera authority itself will demand that furnish these things. Then the builder will have to comply with all of those provisions as and when he receives. When we were studying the sections, we came across many compliances, because these BMC orders also take a while, right? सब एक साथ नहीं आएगा. पहले फायर का आएगा, बाद में वाटर का आएगा. Then that you have to put in. जैसे जैसे आपके पास आता जाएगा, as more home buyers also start getting included in the project, then you have to quarterly keep on updating as and when the project proceeds ahead.
Okay, ma'am. Thank you.
Ma'am,
Yes, Prashant.
ma'am, will law of contract plays any role in this era?
Of course. It's a contract that you signed, right?
But
All
realize
the law.
something like it shows. But realize something. It shows that some instructions to do. It only shows instruction and what we have to do, no, ma'am. But I want to know, like, is contract plays a crucial role in Vera or not?
Yes. Everything is a contract here. Allottees will first of all sign whether it's a development agreement on which the builders have made the claims and provisions, or whether it's a PAAA, the rent compensation that he's giving for relocation. All of that is on a written contract, based on which you will also file a complaint. So contract
We can
plays
sue them.
role everywhere.
So we can sue them in two ways.
Rera will supersede.
No, I didn't
Rera
get,
has
ma'am.
the utmost authority.
Okay, ma'am. Thank you.
Because court might not entertain, no, because there is already a redressal system. You have to file where you have to file. Anyone else?
Good evening, ma'am.
Yes.
If the promoter or developer is having a private limited company, what you said, the same rules apply even if he is running an firm also, right?
Yes.
The same thing applies to that also, that entity also.
Yes. Absolutely.
Okay, thank you.
Welcome.
Hello, ma'am.
Yes, yes.
Actually, whatever is there in the RERA Act, most of the time, like I've seen that in the agreement between the promoters or the developers and the purchasers, they will be mentioning everything in that
Hmm,
agreement.
hmm, hmm.
Is it because, in order to avoid disputes in future?
Sorry, could you please ask your question again?
I mean, most of the things from the RERA Act, they will be putting it in the agreement between the purchaser and the promoter or the developer.
The conditions, right?
Yeah, conditions. So
What
is
leads
it
to the purchase, right?
is it because of uh, can they make a few changes in them regarding the most of the time I have seen that
Not
promoters and
material
the developers.
changes. Not material changes. So basically, if they're just rectifying errors or, um, for example, if you make a request to you being two allottees, okay, two sisters, they make request to the promoter that you know, as we are sisters, we want flats here and here. But if they are of the same size and if the promises are the same, then they need not let allottees know about such minuscule things, right? So it depends on what kind of changes they're making. If they're making plan layout change or they're making a material change in terms of area, then in such cases they have to update their allottees, take their consent, 75% of it, and only then they also have to upload it on the Rera Authority website.
Okay.
So it's material facts cannot be changed.
Ha, ha, ha. And for making slight
A lot
changes
of
in the
times,
layout of the
allottees might request that please increase. We want to purchase now extra area. We will pay the stamp duty on the same. Then he might
Ha,
make
ha.
those changes. Okay.
Oh, okay, okay, okay.
Hmm.
Thank you so much.
Welcome, welcome. Usually, when these agreements are made, no, PAAA, it's a standardized uniform agreement wherein just the name of allottees change. They're not allowed to make different PAAA for different allottee. It will be the same standard format with different names and different identities, consideration amounts. Rest the facts remain the same.
Okay, okay. Thank you.
Ma'am, if an litigation arises in the period in between the agreement period and the sale deed in between that period, and
Hmm.
if the developer is not the reason for that litigation, for instance,
Hmm.
say example that the old owner who has sold this who has sell this land to that developer and he has put some litigation on that case, then in that situation, what will be the status of the client if we don't want to
Hmm.
take the refund?
Hmm. So basically, you're saying the prob the litigation is not between the developer and the allottee, it's between the l- previous owner from whom the builder has bought, right?
Exactly. Yes, yes,
Then,
exactly.
so for example, it could be two ways. Maybe he's been fraud or he has defrauded. Two reasons, right? Then
Yes.
that litigation will have to get cleared first.
Okay, till that he will not get anything
He cannot
till that. He has
stay
to wait.
order
There
lag
is no
jayega.
option.
Yes, yes, stay order लग ही जाता है ना. We see a lot of times 3 floors का बन जाता है, 4 floors का बन
Yes.
जाता है, stay order लग जाता है.
Okay, okay, okay. Thank you.
Welcome. Okay, at this
Uh,
note,
if,
I would like to give my vote of thanks to Legal Vidya for having me here as a speaker. It has been great. I'm also sorry if I was not able to explain you all the concepts. I have given my best. So thank you
uh,
so much to the entire team and also to Legal Vidya for having me here as a speaker for this 3-day workshop.
Thank you, ma'am.
Yes,
I am
yes.
so sorry. This is the last question I will
Yes,
ask.
yes, sure. Sure.
If the builder has taken mortgage the building, the uh,
Hmm.
building for raising the fund. So can the allotee
He
also
cannot
mortgage?
mortgage. And if such a mortgage is made, then the heavy penalties would definitely be levied on him, because mortgage is not a means to increase investment. If he reaches out to other promoters, then also he has to update it on the Rera website.
No, no, like both the if the builder has already mortgaged in order to raise the funds for development purposes, so can the allotee also mortgage the same flat for taking loan on it?
No, neither the builder nor the allotee can mortgage it.
Thank you, ma'am. Thank you so much.
Yes, I will have to leave. Uh,
Yes, ma'am.
I
Let's
have a
wind up
call.
this session.
Yes.
Thank you so much, ma'am, for such an understanding class and also covering all the aspect of Rera. And also thank you, participant, for joining this session and making engaging this session. Thank you, everyone. Kindly fill the feedback form for the certificate and the feedback form link given in the chat box. Thank you, everyone.
Thank you so much, everyone.
Thank you, ma'am. Thank you so much.